the unwanted standard in sexual harassment cases. And we have a contrast between the federal and the California jury instructions as to what they say. California is using the unwanted word, that the advances by the male or the conduct by the male, typically it's male, female, were unwanted. Title VII uses the word, in the federal courts, unwelcome. I tend to think the word unwelcome is a little stronger than unwanted, but the key is that the non-legal defense, the factual type of defense that comes up that they're trying to create on the defense of a sexual harassment case. And Dr. Zapper is going to help us talk about this a little bit more on the psychological side of things, is that, well, the woman gave her consent. Now, this comes up very large in a quid pro quo case where there's some actual sexual contact between the two. Obviously, if it's rape, that's not a question. There's no consent, so therefore it's unwilling, it's unwanted. That's not a big deal. But it usually isn't rape, at least not the cases that we see on the civil side. So the psychology and the development of the psychological case becomes critical. And I think in a plaintiff's practice, you have to engage a psychologist very early in the case for counseling, and perhaps even for counseling as to whether or not the employee will bring the case. Because when a woman finds herself in a vulnerable position in the workplace, and there is some quid pro quo type of activity that happens, she may not want to bring it out. She comes to you and she says she definitely wants it to stop, and she's looking for a way to get out of it. But she may have family at home that don't know about it, and a lot of other factors that are worrying her about it. And it becomes a real stressful item of needing treatment, needing help.